Good morning. It's 11:30. We're going to get started. I'm Lisa Grennan, the Family Program Manager in MWR. Welcome to Estate Planning, Protecting You, your family, and your legacy. And today our speaker is Stacey Lott. She is a attorney and Juris Doctor degree that she has through the state of Michigan. She practices elder law and probate and estate planning. And we are so excited to have Stacey back again. She is very knowledgeable. And thank you, Stacey, for being here. Welcome.
Thanks for having me, Lisa.
Sure.
Okay, are you guys ready?
Yes.
All right. So those of you who've been here with me before, you know that I have this little questionnaire that's called the most frequently asked questions in estate planning and elder law, and I have it again this year just because even though it's kind of a framework of what we'll talk about today, there are little bits and pieces that I'll add in that kind of change from year to year, or things that I have noticed a lot in my practice this year that I just kind of want to talk to people about so that you don't fall into a trap that I've seen some of my other clients fall into. But we'll go through the questions just to kind of give us an outline of how to go. So the first question that people ask me is, what is probate? Because you hear these horrible horror stories about, oh my gosh, we don't want to go through probate. Probate's awful. And probate is basically a court proceeding where the judge will pick a person to be the personal representative, which is, some people call it the executor of an estate, to make sure that whatever was in that person's name. So if I passed away tomorrow and my house was just in my name and it had to get to my husband or my kids, then in order to get it into their name, it has to go through probate to get to them. Okay, unless I did something in advance, like did a ladybird deed or did a trust or did something, which we'll get more into. So it gets from one person's name to another person's name. And there's a couple ways that can happen. Either the person doesn't have a will or any estate planning documents, and so it goes the way the state of Michigan says, to your next of kin. Or if someone has a will, the will say, hey, this is the person I want to be my personal representative. These are the people I want to get my assets. And then the court will just follow that, and that's how it happens. So I guess that kind of tips you off right there that a will is not enough to avoid probate. And that's one of the first things I really want to talk about. Yesterday alone, I had 2 different clients come in and say, well, she had a will, so we shouldn't have to go through probate. And these aren't clients of mine. These are ones that have come since the person passed away to have me help them with administration. And I'll say, a will does, spell out where things go and who's in charge, but it does not avoid probate. So that's a big misconception. I think that, a lot of attorneys, back in the day, especially would tell people, hey, you just need a will. This is fine. You're not a millionaire. You don't need a trust. And people thought the will was enough to make sure their assets didn't go through probate. But I'll be honest, there are a lot of attorneys out there who do that because they want to probate your estate someday because they'll make more money. And it sounds horrible. And I'm not going to name names or anything, but it's very, very common. And to me, it seems so simple to be able to avoid probate by doing, whether it be through a trust or whether it be through different types of beneficiary designations, or something called a ladybird deed, which is a deed that says I own my house for my lifetime, but then upon my death it transfers to whomever I want it to go to. There are ways to avoid probate without other than just doing a will, because a will isn't going to do it. And so I think that's probably the first thing that I really, really want to stress to people, is that even if you only have a will, that's not enough to avoid probate. Now, some people will do a will and then their attorney will say, but make sure you have beneficiaries on everything. We can do a quick claim deed that adds your kids to your house, all these little, kind of behind the scenes things, because joint ownership and beneficiary designations, those things actually trump a will or a trust. Those things go directly to the person before anybody looks at the estate planning documents. So some people will have a will, but then they'll just have all these other things done through beneficiaries or through deeds. And You have to be really, really careful about that because there are times when, say, for instance, I'll use myself as an example. My mom is still with us, and I have one sister. And if she left everything to us, through beneficiary designations, but we know we have to sell her house when she's gone. And if I get half of the assets and my sister gets half of the assets and I'm the one doing everything and I'm spending, a part of my portion to pay the bills on the house till it sells or to do an estate sale or to, try to get things cleaned out or, maintain the house or get the roof done. And then I say, you know what, Kelly, my sister, I spent all this money, getting the house ready to sell. Can you reimburse me, half of it so that we can both pay for it? She's like, oh my gosh, Stacey, I didn't know you were going to do that. I used my money to pay off my mortgage. And it's like a very innocent mistake, but it happens all the time where the person who does the most ends up with less. And that's never anyone's intent. Just trying to avoid probate isn't the only reason to, have beneficiary designations on everything. And, avoiding probate is one thing, but you have to also look at the fairness of an estate too. And that kind of brings me into our next question. What's the difference between a will and a trust? Once again, I already talked about the will. It tells everybody what you want to happen, but it doesn't avoid probate, right? It's public record. If you go through probate, everybody kind of knows what's going on. Anybody can look it up because it's a probate court proceeding. A trust is a little more private. And in our case, my mom does have a trust, and it says everything goes 50-50 to my sister and I. And everything that needs to be liquidated, like the house sold, things like that, vehicles sold, all of that would happen before we distribute the money 50-50. So the trust pays the bills on the house until it sells. The trust handles any type of expenses. And then after everything's been liquidated, all the bills have been paid, then everything gets split 50-50. So as far as fairness goes, a trust is, pretty good because it makes sure that no one is paying out of their portion to make sure things are taken care of, the administrative stuff. And also it makes sure that it avoids probate, right? Because when you have a trust, the whole point is, so my husband and I have a trust, and we have a quitclaim deed where our house is owned by our trust. We have our bank accounts are owned by our trust. Our life insurance, the primary beneficiary is our trust. So that when something happens to both of us, everything goes into this pot, and our trustee can use that money to be able to pay for things for our kids until they're old enough to get it, to liquidate everything, do everything they need to do. And then at a point in time, everything's split 50-50 between my kids without anything going through probate. And then you heard me say when they're old enough to get it. My twins are 19. I don't think 19-year-olds are old enough to be able to receive, an estate from their parents. I personally don't. My kids aren't. Anyway, they're not responsible or mature enough to do that yet. They're great kids, but I don't trust a 19-year-old with half of my life insurance, so we can spell out in a trust at what ages it's appropriate for kids to get their money. So ours says they get a third at 25, a third at 30, and a third at 35. And then the trustee, who is my friend, can use it for anything they need up until they reach those ages. So if they need anything for their health, education, maintenance, or support, my friend can use it for those things for them, but they're not going to get cash in their hot little hands to blow however they want until they're a certain age. So that's another thing you can do in a trust that's really difficult to do in a will. So without having to go through probate, which is, it's hard. So trusts also are really, I think, important when you're looking at a second marriage situation. I'll go back to my mom again. My mom is remarried to my stepdad, but her trust says everything goes to my sister and I because she had her own assets going into the marriage and he had his own assets going into the marriage. His trust says everything goes to his kids, so that someday when she's gone, if my stepdad's still alive, there are a couple little things that he does get, out of, like a life estate in the house and a certain life insurance policy, but everything else that my mom and dad, built up together, that would go to my sister and I, and not to my stepdad. So it would end up with his kids someday. So second marriages or third marriages or fourth marriages, that's a great reason to do trusts. Other reasons are if there's someone with a disability and we have to do some type of special needs trust. We also do specific types of trusts when we're applying for Medicaid for people. If there's a married couple and one of them, falls and breaks their hip, they end up in the nursing home for rehab. And then the nursing home says, hey, I don't think it's safe for you to go home. Then the spouse can come see me and say, what do I do? It's $10,000 a month. I'm not sure how we're going to afford that. And then we can do some type of planning that can help protect assets for the spouse who's not in the nursing home. And one of those things is an irrevocable trust that we can do at that time, not in advance, but at that time for the spouse. There's other tools that elder law attorneys can use as well. And we'll get into that a little bit more when we talk about if I have to go to a nursing home, will I lose my house type of thing. But there are different reasons why trusts are important. And those are some of the ones that just right off the top, we would do a trust in those scenarios. But once again, the majority of the people who do trusts, they're living trusts or revocable trusts. Those people do them because they want to avoid probate and make everything very smooth for the person who's administering the estate after they're gone. Which leads me to my second thing that has been popping up a ton this year, and I don't know why or what's happening, but when one of my clients passes away and they have a trust, and the trust is the beneficiary, or I'm sorry, the trust is the beneficiary of maybe a credit union account, or the trust is the owner of a bank account. And then after a person dies, their social security number ends with them, right? So in order to be able to pay bills out of the trust and to report income to the trust, to the IRS, we have to have a tax ID number for the trust after the person dies. And at that time, the trust then becomes irrevocable, which means nobody can change it because the grantor, the person who made the trust, is gone. So nobody can go in and mend it at that time because the person whose trust it was is no longer with us. So we can't have the kid go in and change it to say I get 90%, my sister gets 10%. It becomes irrevocable or unchangeable. So at that time, when we get the tax ID number, usually an accountant or your attorney is the one that will get that for you and tell you how to go to the credit union or the bank and set up the trust account with the new tax ID number. But we have had in the past maybe 2 or 3 weeks, several different people come to us in Michigan and out of state telling us that the credit union gave them the advice to go online and get their own tax ID number. And every single one of them had problems with it because they did it a different way than it needed to be done, whether it was a mistake on the date of the trust or whether it was the wording of the trust or the name of the trust. To think that a layperson could go in and do it is for a credit union to give that legal advice was really shocking to me, and it's been happening over and over and over again. So if you're in that situation where you're at the credit union, they're like, yeah, just go online and get your tax ID number. Don't do it. Talk to someone, your accountant or your attorney or somebody that can help you make sure it's done correctly, because people have been having all kinds of trouble opening up the new account because the tax ID number is wrong or the name of the trust is wrong. Because of the advice they're getting from the tellers at the credit union. And now it's not every credit union, obviously, but it has been several credit unions. And I don't know if there has been some big, national thing at credit union association meetings or something that's been telling people to do this, but just be really careful. That's something that we've been noticing a ton lately. And if someone has told you to do this, I would caution against it, just because we've been having to fix a lot of mistakes that would have been so much easier if we had just done it in the first place. So, or your account had just done it in the first place. So that's the second big thing I kind of wanted to talk about on top of our 5, our most, frequently asked questions. Then we'll go to the next question, which is, what is a living will? Well, a living will is, the wording of it is, people kind of get that confused because there's a living will and then there's a living trust, right? A living trust is what most attorneys in Michigan are talking about when we talk about a trust you do for your family, the things I just talked about, a living or a revocable trust, where you can avoid probate, but you can change it while you're still alive, very simple estate planning, easy trust to make. But that's different from what people call a living will. A living will is a document that's called that in other states, and it's basically a medical power of attorney. In Michigan, we don't call it a living will. We either call it a patient advocate designation or a durable power of attorney for a healthcare or a power of attorney for healthcare. In other states, this living will document, I think Florida is one of them, they allow you to write out exactly what you want to happen at end of life. If you want people to pull the plug or to, not give you, hydration or food, like no feeding tubes, no whatever. I don't want electric shock treatment. I don't want this. I don't want that. You can spell it all out, and then the doctor has to follow it. Okay. As long as you were competent when you did it, the doctor will follow what you wanted. In Michigan, our law says that you pick a person to stand in your shoes and make a medical decision if two doctors certify that you can no longer make your own medical decision. And that's a patient advocate, that person, okay, or the agent under a power of attorney for healthcare. So I always say be very, very careful about who you pick. Make sure it's somebody who could do those things. And I always make fun of myself and say I couldn't do it. I would cryogenically freeze my mom and put her in the attic or something. I would do something to keep her with me forever. But make sure that you pick the person, if you have someone in your family that has a medical background, they would know, they would understand. Maybe they'd be a perfect person. Or somebody who doesn't have a differing religious belief. I've had that issue, and I know I've talked to you guys about it before, but I've had an issue with a daughter who was a Jehovah's Witness, and her dad wasn't, and she wouldn't allow a blood transfusion even though he wasn't. And he ended up surviving, but it was a huge issue trying to get the second person in line up from Florida to fix it. And so that living will, which is a patient advocate designation in Michigan, is so, so important because it is like I said, you have to trust the person to do what you want to do. You have to have that conversation with them that, hey, if I get in that situation and the doctors say there's really no way she's going to be able to come back and have a normal life or a productive life. And I know that if you pull the plug, I could just go peacefully and that's what I want. Make sure you have those conversations. Or, hey, do whatever you could do. Keep me alive as long as possible. They could come up with a cure for what I have, in the next month, and I would have missed it. Whatever it is, just make sure the person that you pick is willing to do what you would want. Also, the other thing that's really important, I think, about a patient advocate designation is that it does take two doctors to certify that you are no longer competent before someone can come and make those decisions for you. So there are people who are physically unable to do things, but mentally competent. People with ALS, for example, whose muscles are deteriorating at such a fast rate, and all they can do is blink to give answers. As long as you can blink yes and no, they're going to ask you before they ask somebody else about what you want. And I love that. I feel like your health decisions and your end of life decisions are so sacrosanct in the state of Michigan that we do have to have two doctors to say this isn't going to work unless they can't do this anymore. You can't come in and make a decision for a person as long as they can do it for themselves. And that's kind of different from a financial power of attorney where you can write it, where two doctors can be required to say that you're incompetent before the person can start paying your bills and taking care of things for you. But the way I look at it is if you don't trust a person to pay your bills and not steal your money, then why would you trust them when you're incompetent and you can't stop them? If you don't trust them now while you are competent and could stop them, why would you trust them if you're incompetent and you can't stop them? So I always say, if there's a question, if you want to wait till two doctors say you can't do it before you let these people do it, then maybe you don't really trust them. And if you don't really trust them, are they the person that you'd want on here? Because there are situations, like I said, where the person might be completely competent. Maybe they have their leg in traction in the hospital and they can't get to the bank, but they have to do something and they want their daughter to go do it. And we don't want two doctors to say that they're incompetent because they're in traction. Then the way I usually write it is that it's effective immediately and that your family could go help you, or your friend or your whoever could go help you, even if you are competent, because you just might not be able to get to the bank that day or go see your lawyer that day or go to the financial advisor that day, but you need to get something taken care of and they could do it for you. So, so that one, I feel like you just have to be very careful about who you pick. And if you don't have anybody, there are professional fiduciaries who can do it for you. And, you know, most attorneys' offices will have a list of those people that they would suggest, or you might know somebody that could step in and take care of those financial things for you if you didn't have anybody that you trusted to do it, if you couldn't. Finally, I guess, well, it's not finally. These last two kind of go hand in hand, but it says, if I have to go into a nursing home, will I lose my house? So the beginning of it kind of talks about estate recovery. So I'll get people who come see me who are in the nursing home, or one of them's in the nursing home, or both of them, or whatever is in the nursing home, and they are eligible for Medicaid. They have one house, one car, you know, less than $2,000. They can go on Medicaid right now, but they don't think about the fact that after they're gone, that house, the state of Michigan can come back and try to take that house to get reimbursed for what they paid for the person's care while they were alive. So there are ways around that. If you're eligible for Medicaid, the nursing home has helped you apply for Medicaid, you're on Medicaid, but you do have a house, it's so important to get to an attorney to have them help you protect that house, because in order to be eligible for Medicaid, you are allowed to have a house, you are, but after you're gone, that house would have to go back to the nursing home or to the state to help pay for the care, you know, that they provided. However, if the house doesn't go through probate, the state can't come back after it. But then the caveat to that is, if your house is in your trust, it counts as an asset and it's not exempt. Sorry. And it makes you ineligible for Medicaid. So 1 second, let me sip my water. If that happens, then you can't get on a Medicaid. So it's kind of like this catch-22. So what we need to do is make sure the house isn't in a trust. It's just in your name if you're going on Medicaid, but we also have to make sure it doesn't go through probate so the state can't come back after it. Hopefully that makes sense. Well, the way that we generally do that is with that ladybird deed we were talking about earlier. If my mom went to the nursing home and she were single and she was eligible, she had less than $2,000 in a house, you know, and she was in the nursing home, and we were like, gosh, you know, when she dies, they're going to take, you know, our family home. Then what we could do is something called a ladybird deed that says my mom owns her house for her lifetime, but then upon her death, it goes to my sister and I. And that way it doesn't go through probate. It stays in her name for her lifetime. So it's exempt for Medicaid purposes, but the state can't come back after it because it doesn't go through probate. It just goes to Kelly and I, my sister and I. And that's so important, that even if someone is eligible for Medicaid, that they understand that if there is real property, that we have to do something with that before the person dies to make sure that it doesn't go through probate. And you can't just add your kid to the deed like, hey, I'm going to quit claiming my daughter on here with me, because there is a 5-year look back about giving things away. And that 5-year look back includes adding someone to your accounts or to your property, because it's a gift of half of that, or whatever percentage, if there's 2 kids being added on, of that property. And that's part that falls into that 5-year look back where you can't give things away. So a lot of times people try to do it themselves, their own little kind of estate planning way to make sure nothing goes through probate, and it ends up triggering that 5-year look back. And that's really hard. So it's just so important that you get good advice when it comes to anything to do with nursing home or Medicaid, because the rules change quarterly for Medicaid. There's this thing called the Bridges Manual, and the Bridges rules change all the time. And some people who really don't practice in the area of elder law may give you advice like, hey, you can give so much money to your kids every year, and you don't have to report that. Well, they usually say 10,000. If there are 2 properties, can they be designated to 2 different children? Oops, I saw a question. Go ahead.
Stacy, could you turn on your camera? We should have asked you at the beginning.
Oh,
I
sure. Yeah.
apologize, so
Sorry,
everyone
guys.
can see you. And
Maybe.
then I'll read the question that we have, just because we have a lot of people on the phone or not connected and can't see it. It says, if
There
there
I am.
are, oh, there you are. Thank you. If there
Uh-huh.
are 2 properties, can they be designated to 2 different children and accomplish the
Yes.
same, or is it only one property?
No, well, so as far as Medicaid goes, you're only allowed to have one house that's exempt for Medicaid. So if that's that question, then there's only one property you're allowed to have. If it's a single person. If it's a married couple, you can have more assets, depending on what you have. But for a single person, if you're on Medicaid, it's one property only. But if you're not talking about Medicaid, if you're talking about just estate planning, you can put both properties into the trust. And if you have a trust, and then in the trust, it could say this one goes to this daughter, this one goes to this daughter, or you can do two separate ladybird deeds. Yep, this property goes, I own it for my lifetime, but then it goes to this daughter. I could say that for my family. If I get my mom's homestead and my sister gets my mom's cottage, it could be two separate ladybird deeds doing that. Absolutely. So for Medicaid purposes, you're allowed to have one exempt home and $2,000 in other assets. You can have a prepaid funeral, a little bit of life insurance, things like that. But as far as a home, if we're talking about Medicaid and a nursing home, you're only allowed to have one. So, but that one property, we want to make sure the state can't come back after. I'm so sorry I didn't have my camera on, you guys. Lisa, I was so on it, getting on early too, and then look at me. So, okay, so the nursing home question, that I just can't, I guess, iterate enough that it's so important to talk to an attorney about what the rules are before you do anything when it comes to nursing home. I have people that are giving away $10,000 left and right to their family members after their husband's been diagnosed with dementia. And there's a 5-year look back on any gift, even though the IRS says, this year, I guess the IRS amount is 17,000. It's not 10,000. It goes up every year, but if you gave that $17,000 away to your kids and grandkids, or whatever, it's going to count as a gift for Medicaid purposes, even though your accountant or your financial advisor or your hairdresser or your best friend told you could do it. Don't do anything that you think is the right thing to do for Medicaid without talking to somebody who really knows the rules, because it's so hard to undo what's already been done. Just the Medicaid rules are different from IRS rules and from other rules as far as accounting goes and stuff like that. So please make sure that you talk to somebody about that before you do anything on your own, if that's what you're trying to do. And then that kind of leads me into that last question of, can't I just make my children co-owners of my house and other assets? And I talked about that. If you do it within 5 years, then we have that 5-year look back period. And of course, we don't have a crystal ball. We don't know when people are going to need to go on Medicaid, or if they are going to get sicker, or if they are, there are some diagnoses that we just know. If you have dementia, it's not going to get better. It's debilitating. You're going to deteriorate. We know that, ALS, Parkinson's, those things, it's awful, but we know it's just going to get worse, right? But there are some times that I have clients who do get better from whatever they have that took them into the nursing home. Maybe their broken hip that got an infection, and they just can't get home and walk on it yet. They can't do anything, and they're a 2-person assist, and it's awful. But then after some rehab and some time and some wound care and all these other things, they are strong enough that they can make it home. And, it's hard to be able to decide, what we can do to protect assets if we don't know if a person's going to make it home or not. So that's why that 5-year look back thing is so tricky for us. Also, adding your kids to assets not only is tricky for that 5-year look back, but there's several other reasons. And I've told this story before, but I'm going to tell it again because it's the one that always stands in my mind, because I can remember the look on his face when he came to see me. But I had a man come in who had not much, and his little nest egg was about 70,000 in a money market account at his credit union. And he had adult daughters and grandkids, and and he had his 2 daughters on that account with him. So if something happened to him, because the people at the credit union said, hey, just add your daughters to it, and then if something happens to you, they can have access to that account to be able to pay bills, or if you pass away, it just automatically goes to them because they're joint owners. So he added them to this account and to his checking account, which didn't really hold much, but then his daughter ended up getting a divorce. And my first thought was, oh my gosh, her husband tried to get half of that, her, account because her name's on it. He didn't. She was just so angry because the husband had an affair that she just kept going back to court with all these frivolous things over and over and over again. And finally the judge is like, listen, if you don't stop coming to court for, frivolous arguments, we're gonna order that you pay your husband's attorney's fees. And she did it again, and she got this huge order for her husband's attorney's fees for the last like 3 hearings they had about her, all of her frivolous accusations. And she didn't pay it. She didn't pay the attorney fee. And so the attorneys got a judgment against her, and they looked for anything that had her name on it, and they sucked $40,000 out of her dad's account because her name was on it and she was an owner. And he's just like, I never thought in a million years that something like that would happen. Like, I trust my daughter, she didn't have the money to pay it. She was angry, and now here I am with $30,000 left in my little nest egg because of something, just because of having my daughter on my account. And if I had known, I never would have done that. And the simple solution is make them the beneficiary and then have a power of attorney so that they could get access to the account to use that money if they needed to for him. But then upon his death, it would just automatically go to the 2 daughters without them being on the account. And we lose that liability just like that. It's so simple to fix that. But people who aren't attorneys over and over again are telling people to, hey, just add your kids to the account. And we can do the same thing with a beneficiary designation and a power of attorney than adding your kid to the account without any liability. And then the final thing is losing kind of control of that account. Well, first of all, if it's a bank account and you're not certain you trust your kids 100%, maybe you become incompetent and they're on that account and the money's only supposed to be used for you, obviously, but maybe there's a big bill that one of your kids, owes, and they're like, you know what, I'm just going to take it out of this account. I'm going to put it back in the next couple months. I just need a little loan, like 10 grand. I'm going to take out of here. The best intentions. And I promise I'll put it back, tells their sibling that or whatever, takes it out, and then the money never gets back. And it's not like they didn't mean, they meant to put it back, but it never went back. You have to know that the people that are on these accounts will never touch your money for their own personal use. And they might not be bad people. It might be like, I truly intend to put this back next month. I'm just really short right now. And I'm stuck and I don't know what to do. Or if I have an example of my sister and I, if we were on my mom's cottage with her, and my mom was like, this is too much upkeep. I just don't want this anymore. I want to sell this. I'm done with it. But my sister and I both know that this cottage is worth a lot of money because it's on this lake where Lloyd Carr lives 3 doors down and Jeff Daniels is down around the corner in Chelsea, where I grew up. And we know if we hold on to this piece of land, it's going to be worth a ton of money in the future. And we can both say, no, Mom, we don't want to sell it. We're going to keep it. We're owners too. And you can't sell it without us agreeing. Now, we would never do that to her, but some kids do, and I see it all the time. It was the hunting land that Dad wanted me to have, and I'm not going to let you sell it, and I'm sorry, and blah, 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 blah. And the mom wants to sell it because she needs some extra money, and the kid's like, nope, this is going to be my hunting land someday, and you can't sell it. And you end up in court fighting with your parents or your kids because you don't have control over the property anymore because you added your kids as owners. So once again, an easy solution to that is either put it in a trust or do a ladybird deed where you own it for your lifetime and your kids only get it upon your death. And that way it doesn't go through probate, it ends up with them, but it doesn't make you lose your control. It doesn't affect that 5-year look back. It doesn't have any type of liability as far as your kid getting a judgment or getting sued. I mean, if your kid got in an accident and hurt somebody and they sued them and their insurance wasn't enough to cover it, and then they go into their assets and they take, your house or your bank account because the person had a creditor against them. Those are things that people just don't think about when the person of the credit union says, hey, just add your kids to it. Or somebody says, hey, just put your kids on your deed. It's this kind of quick and easy estate planning that you can do on your own that has lots of a multitude of things that could happen that are negative liabilities that just pop out at attorneys all the time that we're like, oh no, don't do it, but I really think that people having a quick consultation with an attorney that might be a couple $100 is just worth its weight in gold when you could avoid so many pitfalls, by doing that. So, like I said, a good durable power of attorney and beneficiary designations with trusts or things like that can do the exact same thing as adding your kids to these, assets without having the pitfalls that could happen. So, boy, I went
Stacey,
past. Yeah,
question.
yeah.
So if you are on your parents' account and say they get in a car accident and get sued for this accident because they're liable, and would you be sued because you're on that account with them?
Nope, so it's the opposite. Okay, if
Okay.
your mom was on your account and she got in an accident, they can come after your money.
Okay.
Okay. But if you're on your mom's account and she gets in an accident, you're not liable for that. Her money goes away. You're not going to get sued. You're just going to lose money, right? Out
Lose
of her,
her money.
right.
Okay.
But if you, it's surprising how many people, my husband included, after they were married for years, didn't realize that they had their parents on an account somewhere or had their parent as a beneficiary, because when they were single, they just added their, hey, I have my mom on this account, like I'm on my kids' accounts, and if I got in an accident and I'm on my kid's account, they can take my kid's money because I got in an accident,
Okay.
so adding your mom to your account is going to affect your assets, but you being on her account, and if she gets in an accident, it doesn't affect you other than what money was in her account that you were on.
Okay.
Okay, does
Thank
that make
you.
sense?
Yeah.
Yeah, okay. And then one thing I really did want to talk about that's not on my list, and it's I think I mentioned it in there somewhere, is veterans benefits. I think people sometimes forget that they're out there. There is a veterans benefit called the aid and attendance pension that can help pay for long-term care for people who are in either at home or in an assisted living or adult foster care. We don't normally use it in a nursing home because the benefit isn't enough to cover a nursing home bill, but the monthly income that this pension gives people when they need care for a single veteran, it's $2,000 a month. It's actually $2,050 a month for the surviving spouse of a deceased veteran. It's $1,432 for a married veteran whose spouse needs care or they need care or they both need care. It's $2,431. And then for two married veterans, it's $3,536 a month. So if you have enough income that could cover half of the rent at an assisted living facility, but you need a little bit more to get the rest of it, this benefit is fantastic because for Medicaid for a single person, you're only allowed to have one house, one car, a prepaid funeral, $1,500 in life insurance, and $2,000 in the bank. For VA, you can still have that one house, one car, a little bit of life insurance, that kind of stuff, and $150,000 for a single person, and get $2,000 a month from the VA for the rest of your life. So I have clients who might have $2,700 in income total between a pension and Social Security every month, and they want to go to a assisted living that's $4,200 a month. Well, this extra $2,050 is exactly what they need to be able to pay for the monthly payment at the assisted living facility without having to dip into their savings. And you can have up to $150,000 plus a house. So you could have a house and a cottage worth $120,000 and $30,000 in the bank and still be eligible for VA. And I think people just don't think about it. Now, there are a few. Can you repeat that program and what can be used paid for? Is it only assisted living? No. So I'm going to go through I'll go through the rules right now. There's 4 prongs to it. It's called the aid and attendance pension. I know I talk fast, so I'll slow down a little. The aid and attendance pension, and it's a VA pension that can be used for people if they meet these 4 criteria. The first criteria is they had to serve during a period of active war. And that's tricky because I have people, especially right now, who fall in between Korea and Vietnam. And there are specific dates. I have a whole chart and you can look it up, but that tell you the dates that work as far as Vietnam goes. Like you can be a certain date, but you had to be in the Republic of Vietnam. But if you were never in the Republic of Vietnam, but you were active duty, there's different dates. And so I do have a lot of Vietnam veterans now who have Agent Orange exposure, who have lots of health issues, who I'm helping with these benefits. But you, or if you're the spouse of a deceased veteran, your ex-spouse has to, or your former spouse has to have served during this period of active war, okay? You have to serve 90 days total, but only one of those days had to be during a period of active war. So if you went in the day before that date ends, it works. As long if you were in for 3 months, it works. So it's kind of cool. The other thing is that you had to be honorably discharged, or it couldn't be somebody that was dishonorably discharged that could get it. And that's important too. So that's the first prong. The second prong is that you need the care. So basically, you need help with at least 2 of your activities of daily living. Like you can't bathe yourself, you can't dress yourself, you can't groom yourself, those types of things. You can't get the fork to your mouth. Now, it's not, I can't make my meals, because that's not an activity of daily living. It's the actual things that you need to do to help yourself. But a dementia diagnosis in itself is enough, and being legally blind is enough too. Those 2 things automatically make you eligible medically. The third prong is that your income every month that you get from your Social Security or your Social Security and your pension is not enough to cover your medical expenses every month. So the rent or the price of your assisted living is considered a medical expense if you medically need to be there. And so that's how most people would qualify, because gosh, monthly that $4,000 is more than I make, right? Or you can also use it for home care, and that was one of your questions. So if you have somebody coming in to help out at home, and their bill is $2,500 a month, and your income is only $1,800 a month, or maybe their bill is $1,500 a month, your income is $1,800 a month, but you have prescription copays, depends, lots of other things that when you add it all up, doctor's visits, copays, when you add it all up, it works out to another, $300 or $400 a month. You add all of the medical expenses together, and if the care expenses and the other medical expenses outweigh what your income is every month, then that's how you qualify income wise. And then the fourth prong is the asset limits, which we just talked about. It's $150,538 that you're allowed to have on top of your house. So it's such a good benefit, especially for single people who have, 50, 60,000 in the bank that they don't want to spend it all down at the nursing home. And they have decent income, and just this little extra 2,000 a month will bump them up enough that they can afford to stay in a nice assisted living or adult foster care home, or they can get help in their house. It's such a good benefit. And the tricky thing about this one though is that it's really kind of hard to apply for. And everybody knows the federal government, it's very form driven. It can take some time. And there are service centers, each county has one that can help. Several years ago, Calhoun County, their people got in big trouble and ended up, in prison because they were making deals with people that if you pay me this much, I'll get you the benefit. It was awful. It's not like that now. They've got great people, but they might not know some of the tools that people can do to be able to make people eligible for VA. Now, VA, when they changed it so people can have 150,000, it's a big jump for what it used to be. They also put in a 3-year look back, just like Medicaid. You can't give anything away within the 3 years we apply for veterans benefits. So, so that's the thing that kind of offsets it. But we have a much smaller waiting period than the 5 years for Medicaid to be able to get VA for people if we have to wait. And it's a benefit that lasts them for the rest of their life. Now, attorneys who help people do the veterans benefits have to be accredited with the VA. We have to go through a whole accreditation process. And so make sure that if you do talk to somebody who is an attorney, that they are accredited to give the advice about the veterans benefits, that they're accredited with the VA. There are some like annuity companies and things like that who come in and try to get people eligible. One of them was called like Senior Veterans of America or something. Like they make these names and then they're annuity companies trying to sell annuities to get people eligible for Medicaid, and they make a lot of money on it. And it might not be what's best in the long term. Like if the person needed to ever apply for Medicaid, if I said Medicaid, I meant VA. If people need to apply for Medicaid down the road, we want to make sure that if we apply for VA now, it's not going to mess up what we might have to do in the future for Medicaid. So a good elder law attorney is going to be able to look forward and think about what we're doing now isn't going to disqualify us for Medicaid later. So make sure that if you're getting advice about any of these benefits, that you get it from somebody who understands it. Okay. So that was the veterans thing was one I really wanted to kind of bring up, because I'm not certain how much I've talked about it, but it's really, really important. And it's a great benefit that people are willing to, when they apply for it and when we get it, finally, it is such a great thing. So, okay. So can you guys, do any of you have other questions for me? So far they've been great questions.
Stacey, with the aid in attendance, when they do get that, do they get back pay for that?
They do. Great questions. Thank you,
Okay.
Lisa. So if we apply in February, it will pay back to the first of the next month. So sometimes it takes, 6 months to get approved, but, we get approved in August or whatever, it will pay back to March 1st. So whatever month we apply in, it will pay back to the first of the next month. Another thing that's important to know, that if someone is incompetent, if they have a dementia diagnosis, that the VA is going to appoint a fiduciary for them, and that a fiduciary, the money will come back and it will go into a fiduciary account that it's probably your person that's a power of attorney. It will be somebody that it's going to be someone that you've listed as your agent under a power of attorney, your kid or your friend or your husband, or your wife, and that money will come back and come into a fiduciary account. So the fiduciary has to be appointed before that big lump sum comes back. But not everybody has dementia or is incompetent. They might have a physical ailment, and then the money just comes back to them. And this is really a great benefit, because we do get the reimbursement plus this pension they get for the rest of their life, as long as they're receiving care. Now, if they do end up having to go to a nursing home and we apply for Medicaid, then it stops. We let the VA know and it stops. But if you're not in a nursing home and you need that little bit of extra money monthly. Oh, another thing that's important, now that I'm thinking about it, is that if you do home care, the VA lets you pay your family members. So Medicaid doesn't. So we have to be very careful about how we do it. We have to set up something that would make it Medicaid proof. But if your daughter moves in to help take care of you, and they sell their house and move into your house and they're there, with the VA, we can actually pay your daughter to be your caregiver, so the money stays right in the house. And it's legal. It's something that we can do all the time, because the VA understands some people do give up their lives to take care of their parents, and they should be able to get paid for it. Medicaid doesn't believe that. They think we should do everything out of the goodness of our hearts for our parents, which of course we want to, but if you're giving up your career to be a caregiver, you should be able to get paid for it, and VA allows you to do that. So that's important too. All right, what other questions do you have?
Hey, Stacey.
Yes.
I missed the first part, sorry, but this is Bill Jerome. Just
Hi, Bill.
In general, and I know that this is not advertisement, but just to tell everybody on there, to get an actual trust from you, is there just a general estimate of a cost and a timeline that it would take to do it for a person and their spouse? Over.
Sure. So I'm probably a little more reasonable than most attorneys when it comes to estate planning, because I want to make sure it's done correctly. Great question, Bill. Because we want to make sure it's done correctly, so that if anything happens with long-term care in the future, all of our ducks are in a row, right? So usually a trust itself could be anywhere between $500 up to $750, depending on the kind of trust it is. Single trust, married trust, special trust, anything. It could even be $1,000 if it's some special needs type trust or something like that. But then you have ancillary documents that go with it, like the deed that puts your house into the trust. You still have to have a will when you have a trust, powers of attorney, things like that. So if you did your trust, your powers of attorney, your deed that puts your house in your trust, your little will, and you only have one piece of property, you're probably looking anywhere between maybe $1,300 up to $1,600, something like that. For a married couple, it lasts for a single person, probably around the $1,000 mark for a single person, or $1,100, because you don't have as many powers of attorney and things like that. It's pretty reasonable, considering probates anywhere between $3,000 and $5,000 in our county anyway, around here. So much less expensive to do that. and get that done right away. If you have a lot of properties, if you have more than one house, I mean, each deed's usually somewhere around $150. So that adds up over time. You know, if you have a lot of properties, you may end up closer to that 2,000 mark or more, because we have to add, you know, for each deed another $150 plus a $30 filing fee with the county. But that's kind of maybe what you're looking at price wise. And then, and that's, you know, maybe it's standard across the board, but I know some of the bigger law firms around charge more than that. And then the other time wise, so it probably takes for me, my office, maybe not, you know, a month to month and a half to get in, unless there's a cancellation, which we get some because we do elder law. And then another, you know, month and a half or so until the documents are done, unless it's an emergency. So because I'm such a small office, if there's an emergency, they kind of trump everybody else. So the happy, healthy people, we might have to wait a little longer to get your documents to you because we have emergent situations come in. The good news is if you're ever in an emergent situation, you're going to be put right at the top of the list. But the rest of us, we just kind of get it done as we can. It could be any, like I said, probably around 6 weeks, maybe 8 the most to get those drafts. And then you just review them and make a time to come back in and sign them. So, and when you come back in to sign them, you don't always have to see me. So you can get in a lot more quickly. But it's not too big of a drawn out process. It could be just a couple months. And I think having something done, knowing that if it's a living trust or a revocable trust, that you can make changes whenever you want to in the future. Just having something in place now is, I think, a really good idea. And then you can always change it later as things evolve over time, you know, so. Okay, so that's for, you know, a full estate planning, everything that you might need, but you might not need all of that. You might already have, you know, powers of attorney that are fine, and it might, and then you can take money off of those things. So, okay, what other questions?
Thank you.
You're welcome. What other questions can I help you with? Can you think of anything else?
So I guess you just mentioned something that, and you may have already gone through it, apologize.
Sure, no.
But the ones that you can't make changes to, in what instance would you want that?
Yeah,
Just-
we did talk about that a little bit. Irrevocable trusts. Irrevocable trusts, we use certain ones for Medicaid planning. When somebody's in a nursing home, their spouse, we try to protect assets for them, and we can do it through an irrevocable trust. We do irrevocable trusts when we have special needs children or special needs people we want to leave stuff to. There's certain ways we have to do it through Social Security rules and through Medicaid rules so that we can protect the assets and still get those benefits for people. That would be a reason to do an irrevocable trust. And then after someone passes away, their living trust or their revocable trust becomes irrevocable upon their death. So nobody can just jump in and change the trust after somebody passes away. Those are the general rules when I use them.
Got it. Thank you.
You're welcome.
Stacey, I just want to clarify. So say that you have a couple children in your investments, you didn't split them equally because you had one child with more needs than the other children. So you gave more percentage, but then you put everything in a trust. Does that supersede? Is that what you said? Or I wasn't sure on that. Or does it?
Let's talk about that. So if you have beneficiary designations listed, so I'll give an example, retirement accounts. Most of us are of the age that our retirement accounts are what is going to be our retirement, like our 401k, 403b, IRA, those things. But we don't really get pensions anymore, right? So our retirement accounts, those ones, if your children are adults, or your spouse is still alive or whatever, we would make people the beneficiary of those for tax purposes, okay? If I pass away, my IRA could go to my husband and he could take out required minimum distributions for the rest of his life after he reaches a certain age, right? Or whatever age I would have been. And I'm like 5 months older than him, so I guess whenever I would have reached that age. So they can do it for the rest of their life. If my husband dies before me, when I die and my IRA goes down to my kids, they get 10 years to get it out. So they can take out a 10th every year and to get it out so the taxes are paid. Because all of that money is pre-tax. If we make the trust the primary beneficiary, the trust doesn't have a lifetime. So it takes it all in one lump sum and has to pay the income tax off the top. So unless there's a reason, we try to make people the beneficiary of retirement accounts, all right? This is kind of a little tangent from what we were talking about, Lisa, I'll get back. So the retirement accounts might have people as beneficiaries. Now, when my kids were minors, or even now, because I think they're too young, my trust is the contingent beneficiary. My Kyle's first, my trust is second, because I don't care if we lose the taxes off the top. I want to be able to hold that money in trust and give it out to them incrementally so they don't blow it all, right? But when they're older and more capable of handling that kind of money, then we can change it to them. So that IRA is going to trump the trust, okay? Any beneficiary designation or anything with a joint ownership. So if I had a bank account that's not in my trust and it's just Kyle and I on it, if something happens to me, it goes to Kyle directly. It's not in the trust. Anything with a joint owner or anything with a beneficiary designation is going to take precedent. It's going to go right off the top before you even get to the trust. So if those, like the IRA had, who am I going to pick on? I think I'll pick on Cameron today because I always pick on Cameron, my son. Cameron gets 20% and Caroline gets 80%, then that's how that would go. But that doesn't mean that's how the trust has to go. Okay, the trust can be something different. Like my house is in my trust, my bank accounts are in my trust, my life insurance, the trust is the beneficiary. The trust owns other investments. The trust has everything else. You can make that a different percentage than what you made your IRA because they're separate. Does that help? Am I answering it correctly, Lisa?
Yeah, but so what if all your investments are already in a trust? I mean,
then that's where in the trust, you're going to put what percentages you want people to get.
but they would get it all at one lump sum unless you designate it differently.
Correct. And that's what most
Okay.
people do, is that's why they want things in their trust. So, because like I said, my trust says they get a third at 25, a third at 35, a third,
Okay.
or a third at 30, a third at 35, because I want it spread out. It might change. I think here I am making Caroline the star of the show, but she could get it all right now and she'd save all of it. Cameron would buy everything for all of his best friends and travel around the world and buy guitars and whatever. I mean, he's the smartest, greatest kid, but that's just where they are right now. He's a 19-year-old boy, right? So, but that can change, right? So we can, when they become 27, we might be, they're so responsible. We can take off this 30 and 35. They don't need it. We can change it anytime,
Okay.
So yeah,
Thank
and
you.
that's where you put it. Yep.
Is there any other questions? We just have a couple more minutes to pick Stacy's brain. So if anybody has any other questions.
Hey, I had one more. This is Bill
Sure.
Jerome again. The trustees. Now,
Mhm.
I've seen this go wrong with friends and family before, but I guess the quick summary of what most people do for trustees and how they actually manage that. What controls them or governs to protect it if you got a bad trustee?
Right. So I'll give an example. I have an example. Yesterday, I had a lady come in, her aunt passed away. She never had any children. So she and another cousin were named trustee together, or either of them acting alone. And she's like, I don't trust her. I don't trust her. She's going to take money out of the account. What can I do when she does? And I'm like, well, what you can do is just keep an eye on it for now. You can't have her removed until she does something, right? We can't prove until she does something. Just one second. Okay, do I need a trust if all of my accounts, TSB, house, etc., have a beneficiary? I'll get to that in just a second. So she just didn't trust her, right? So I said, what you have to do is wait for her to do something wrong. And then when she does something wrong, you can petition the court to have her removed as trustee. So beneficiaries, she's a beneficiary, but that's not what she's worried about. It's a lot of stuff is going to charity, and she wanted to make sure the charities, would get everything they're supposed to get. And she's so worried this woman's going to take money out. So, so I'll give a better example. Let's say there's 5 kids. One of the kids' name is trustee. The kid starts taking money out. The beneficiaries are like, we need an accounting, and beneficiaries are entitled to accountings. So you can always ask for one. Okay. And then if they don't provide it, you can go to court and require them to give you one. And then if they provide it and then you see all these red flags, then you go to court and have them removed as trustee. Okay, then the contingent trustee can jump in, or if there is no contingent trustee, then you can ask the court to appoint a professional fiduciary. And that's, I think, part of your question, Bill. A lot of families don't want there to be infighting with their kids, so they pick a bank or Edward Jones or whoever to be the professional fiduciary. It's really weird that I often get sons-in-law like we'll have families who the husband and wife don't want their daughters fighting. So they pick this son-in-law who's just super, reserved and, back from the mess. And I don't know why, but I mean, I'm not sure how much I agree with that, except these sons-in-law have been fantastic that we've dealt with. But what if they got a divorce? Like, I don't know. But it could be somebody who's just very, very, not so involved and not so emotional. If there's somebody, like that, I always recommend them. Or if you have a kid who, is so fair and won't put up with any crap, or if you have kids who are best friends, it's like two of them, they're best friends. Let's just have them do it together because everything's going 50-50 anyway. It's really hard. It's your judgment call, but a lot of families do ask a professional fiduciary to do it, knowing that you'll have to pay them. And some of them get paid percentages, some of them get paid hourly, some of them get paid monthly. It just depends, and you have to meet with the different companies to find out how they bill. But hopefully that helps.
Stacey, we have one more question that's just
Yeah.
turning 12:30. So, and just for everyone to know, if you have to get off, we are having a Winter Wellness Health Fair on February 8th from 11 to 2 at the Federal Center. And we will have representatives from the VA, and we have about 42 different vendors and community partners coming. So maybe that can answer some more questions, especially on the VA benefit side. But the last question we have is, do I need a trust if all my accounts, TSP, house, have beneficiaries and have a will, power of attorney, and a medical directive?
So the only thing that would concern me a little bit about that is when I spoke earlier about if it's more than one beneficiary. So if you have two kids and they each get 50% of everything, but the house has to sell, and the one kid who's paying all the bills, taking care of everything, it's coming out of their share. And so then they ask their sibling, to reimburse them, and they don't, because, not because they didn't need, maybe they spent their money already. Oftentimes the person who does the most ends up with the least. If you're not worried about that, if your kids work well together, or if it's only one beneficiary, a single kid, you're fine. If it's a single kid, one beneficiary, I'm totally good with that. I told a client yesterday this exact scenario. This is when I'm like, if it's a one beneficiary, a single kid, I think you're perfect. I don't have any problem with that at all. I think you're good. I like it. So, great question though. You're welcome. So
a single kid, thanks.
Yeah.
Okay.
I got it. Yeah.
Well, thank you so much, Stacey. This
You're
is
welcome,
always so
Lisa.
informative, and we so appreciate your time today and helping
Absolutely.
us to figure all this out. It's a lot.
Yeah, no, absolutely. I'm happy to help. I'm always available when you need me. So
Great. Well, thank you so much.
thanks, guys. Take care.
You too. Bye-bye.
Bye.